And I think we're good, right?
Hold on.
Yeah, I see the live stream on top. Okay, perfect. Sorry. Hi, everyone. Welcome. My name is Nepa, and I am a hotline specialist with Housing Court Answers. And today we are going to be having a training on harassment in housing court. So today our presenters are from the Legal Aid Society. Thank you so much. So today we have Patrick Langery and Michael Maskin. They are both attorneys for Legal Aid Society, and they work in Queens, and they are one of the few groups that do one of the few teams that do group advocacy, is particularly in Queens for I believe it's for harassment and general group advocacy. So they will be going over what is considered harassment in housing court, how it differs from maybe what we think of harassment, what can you do, and in particular in this time, I think it's important to know what are your rights as a tenant, what is allowed, what is not allowed, and how it differs from um, what we may as average people think is harassment versus what is legally allowed and what options you have. So with that being said, I am going to turn it over to you guys. Welcome. And again, thank you so much for doing this.
Thank you, Nipa. Thanks everyone for being here. Yeah,
Sorry, I forgot to mention. If you guys have questions, the questions, you can put them in the chat. We will be answering them at the end. So just put them in the chat. And also this presentation will also be shared. So you don't have to like take pictures or anything. And it will be shared after the training. Yeah, sorry about that. And turning it back to you.
thanks. Yeah, thanks again everyone for being here today on a Friday afternoon to talk about harassment in housing court. Just as a brief introduction before we get into the presentation, as Nipa said, Michael Maskin, I'm a staff attorney at the Legal Aid Society in Queens, at Legal Aid Society's housing group advocacy practice, which is a small unit in Queens, but there are other units in all of the boroughs, focusing on representing groups of tenants, tenant associations, fight back against landlords for essential repairs, for neglecting building conditions, and representing groups of tenants coming together to exercise power and build sustainable power and momentum in the tenants' rights movement in New York City. Look forward to answering questions at the end. And with that, Patrick, if you want to introduce yourself very briefly,
Sure.
go ahead and we can get started.
Hi, everyone. Good afternoon. It's Patrick Langhenry. I'm also with Michael in the group practice here in Queens. We do have a small unit, but at the end, maybe you can ask for our information if you have a group of tenants who are working with their landlord. And as Michael said, we have the same units in every borough, legal aid, and other providers too. And we're all allies, and we're here for you. But we particularly really support tenant associations, tenant unions who are meeting, talking with one another, helping each other out. We want to sustain that. And you do the hard work. We just do the legal work, which, to be frank, we make it real simple on everyone. But thank you. And I'm going to sit back because Michael's doing the presentation, but I'll be here for the length and I'll move the slides over. So that's my job.
Thanks, Patrick. All right, so everyone should hopefully be able to see the slide, which says brief history of the harassment law. That's the first slide here. So before we jump in, I'll give a very brief overview of the harassment law and sort of the history of harassment law in New York. This presentation is going to be geared towards tenants and tenant advocates navigating housing court and navigating situations of harassment and ways in which you can bring claims of harassment to housing court, what that looks like, both in an affirmative context in HP proceedings, which we'll get into, and also in answers and in responsive pleadings if you yourself are being sued by a landlord in a holdover or a non-payment case. So we'll get into all of that. But as a brief overview, 1987 harassment of rent stabilized tenants was codified and prohibited. So this training will mostly be about non-rent stabilized units, but we'll have a bit at the end about the rights of rent stabilized tenants as well to raise harassment issues with DHCR and housing court. In 2008, the Housing Maintenance Code was amended to prohibit harassment of any tenant. So not just rent stabilized tenants, but now any tenant in New York can bring harassment claims in housing court in New York City. Then in 2015, illegal buyout offers were added as a type of harassment. And over the years, different enumerated types of harassment were included in this definition of harassment and what that looks like. And we'll get into those as well. Then over the next few years, a series of bills were enacted, which strengthened the harassment law. So again, it added more types of harassment to the Housing Maintenance Code. It created a cause of action for tenants to sue for compensatory and punitive damages for harassment, which was very significant as we think about, what we hope to gain from bringing a harassment case in housing court. And also importantly, which we're going to spend a lot of time on, there was a rebuttable presumption of the landlord's intent if certain enumerated harassment conduct occurs. And we'll get into what that means. But basically, for most tenants bringing harassment claims, the tenant does not have to prove in their initial filings that the landlord intended to make them leave their apartment or give up a housing right. And again, we'll get into that because it can be a little tricky to wrap our brains around. And other programs as well were started. The Certificate of No Harassment pilot program was enacted, where essentially certain owners of buildings need to get this certificate of no harassment before starting construction work or applying for different permits. So it's a very, very brief and condensed history that sets us up for diving in. Patrick, if you want to go to the next slide, of why we want to bring a harassment claim. So, broadly, there are different reasons for going to court. There are different, things we stand to gain and stand to benefit from going to court. But essentially, you want to bring a harassment claim because you can actually win damages. That's part of coming and going to court is, it's an opportunity for you to receive some kind of damages for the conditions that you are enduring. It's also a deterrent for your landlord to stop harassing you or to remediate the conditions. And generally, if you've gone to your landlord a bunch of times trying to ask for them to repair a condition or to fix this or fix that, and they don't do it, housing court can be a way to sit down across the table from your landlord and have a judge order these conditions to be corrected by a date certain. So, if the landlord gets dragged to court, it takes their time, it takes their money, it takes their energy. It can be a deterrent for them to be delaying in the future, not correcting the conditions as well. There's also, leverage that a tenant can get out of bringing a harassment claim or in raising a counterclaim and an answer in a non-pay or a holdover to settle a case. If there's a colorable harassment claim that is that's available and that you have a good chance of prevailing on, that can encourage settlement in a non-payment. That can encourage waiving arrears or getting an abatement, or it can really encourage a landlord to settle where they otherwise might not be. So our office thinks, and I think of harassment and the harassment statutes as a tool that tenants can use to advocate for themselves, to actually, encourage landlords to, and Patrick, I think we're seeing your emails now, or at least I'm seeing your emails now. I don't know if others are as well. But there we go. Thank you. But it's a way for tenants to really assert their rights and get essential repairs done as well. And one other, item I would add to this is there's a real value in talking with your neighbors and in organizing. That this can feel like a very isolated and individual process, but at least in our practice, very rarely, if you live in a building with many units, are you the only tenant who is experiencing this kind of harassment. Very rarely are you the only tenant who has conditions or repairs that need to be made or dealing with other types of harassment. So, forming tenant associations and talking with your neighbors and coming together can be a really powerful and effective way to have building-wide claims of harassment resolved, because it is possible for groups of tenants to come together and file one HP together for the whole building. So this is not necessarily just something that individual tenants have to deal with on their own, but getting organized, talking with your neighbors, and coming together can be a very powerful way to get these conditions repaired and also show your landlord that tenants are organized and aren't going to stand for these conditions. So we'll go to the next slide. Okay, so we'll get into this harassment statute itself, and it's important to understand it because there are parts of it that might seem a little bit confusing or counterintuitive. So the Housing Maintenance Code, the citation is there, defines the elements of harassment, and elements are basically what needs to be established and proven so that a judge will issue a finding of harassment. So these must be satisfied in order for there to be a finding of harassment. So we'll go one by one. So harassment is any conduct by or on behalf of a landlord. So there's a few things here. We're talking about conduct. So there is an action or an omission, or the landlord is doing something or not doing something by or on behalf of a landlord. So this can be conduct that's done by a landlord or on behalf of a landlord. That can be someone who's authorized to act on a landlord's behalf. That can be a managing agent. That can be a super. That can be a custodial staff. That can be someone who has authority to act on behalf of the landlord. And it's conduct against a tenant or a lawful occupant. So it's conduct that is against a tenant, and a tenant is someone with tenancy rights, names on the lease, and so on, or a lawful occupant. And a lawful occupant is someone with permission to live in the unit. So that can be the child of a tenant of record, that can be a roommate, that can be someone with permission to live in the unit. And that's important because a landlord or a landlord's agent, there can be harassment against a lawful occupant, even if your name isn't on the lease. If you are lawfully in the unit, you are covered under this statute. The conduct that causes or is intended to cause, and we're going to delve more into this one as well, because this is an important, the counterintuitive point I was talking about before. But we'll read this with line D, that causes or is intended to cause the tenant or lawful occupant to vacate or waive any of their rights. So the conduct that we're talking about here, that is harassment, must be with the intent to cause the tenant or occupant to vacate the unit, the apartment, or to waive any of their tenancy rights. Okay? And includes one or the more following acts or omissions. So before we go to the next slide, this is what a tenant has to show when they're filing an HP, and we're going to get into what that looks like, to basically meet the initial, it's called the prima facie burden. So your initial burden of showing that there is harassment before the landlord gets to try and raise their defenses, this is what the tenant has to show. Now, for intent, the tenant doesn't need to show that there was intent. And we're going to get into that in a little bit, but this is essentially what a tenant needs to show, that there is conduct on or behalf of a landlord against a tenant or lawful occupant that causes or is intended to cause the tenant or occupant to vacate or waive any of their tenancy rights, and includes one or the more of the following acts or omissions. We'll go to the next slide. The previous slide, one before, Patrick. Yes, thank you. Yes. So this is talking about what harassment is, and the Housing Maintenance Code enumerates several specific actions that constitute harassment. And we'll go through here a few of them that are some of the most common, and I can explain what this looks like. So certainly in my practice, far and away, the most common harassment that we see that tenants face are the first two. So interruptions or discontinuances of essential services. Before I go on, I think this is an important point. When we hear the word harassment, we all kind of have this idea in our heads of what harassment is. There's a dictionary definition, and you can think, oh yeah, this might be harassment, this might be harassment. And it's important to think in the context of housing that there are these specific types of harassment that are covered under the Housing Maintenance Code in housing court. So interruptions or discontinuances of essential services that can be, cutting electricity, the lights are off, you don't have power, so on and so forth. And that can constitute harassment. And for this particular type of harassment, um, it's important to document, and we'll get into that as well, how important documenting everything is when you're starting a case in court. But specifically for this one, you want to document, if you can, before you come to court, that there have been these interruptions or discontinuances of essential services. So if your landlord's cutting your power and you think they're trying to get you to move out by cutting your power, if you can call 311, have an inspector come out and place the violation, that can be very helpful when coming to court because we've seen judges, specifically with this kind of an issue, um, look for a complaint or a violation that has been placed with HPD or DOB or another city agency. Now, this can get a little tricky because if a landlord is cutting power, you call 311. If the power is restored by the time the inspector comes out, it's hard to kind of have this violation be placed. And so tenants are able to come to court, and if there's no violation that's placed, you would have to show that there have been repeated interruptions, or that the denial of services was for an extended duration of time, and that it substantially impaired the habitability of the apartment. You can, on your own, tenants can take photos, videos, um, sometimes text messages, some way to document that you have no power. You're trying to turn the light switch on, and the light's not going on, and you don't have access to the controls, and so on. So this is very common. Landlords will, shut the services off for a little bit of time, but by the time 311 comes out to inspect, the services are back on. So as as much as you can document everything, make photos, videos, and so on, that can really help with this specific type of harassment. The second one, repeated failures to repair hazardous or immediately hazardous housing maintenance code violations. So this one also is a situation where judges in housing court will want to see a violation placed. It's not necessarily, it's not, I hesitate to say it's necessary. It's extremely helpful if you can come to court with a violation already placed. And that's something that we can talk about as well with the question of calling 311 and what that looks like. But these are, generally it's helpful to call 311 and make a complaint about mold, Class B or C violations. That's, mold or water damage or, non-essential services and so on. So an immediately hazardous violation, if a landlord repeatedly fails to repair them, that can constitute harassment. Knowingly providing false or misleading information about the apartment. That can be saying an apartment is not rent stabilized when in fact it is, or providing misleading information about the apartment that can affect a tenant's rights or status. Falsifying certain information to DOB or HPD, commencing baseless or frivolous court cases. And an important note with this one is that um, this is also why it might be helpful to talk with your neighbors. If a landlord commences, you know, a bunch of cases against an individual tenant, that might rise to the level of, a number of baseless or frivolous court cases. But if it's just one or two, that's a little bit more of an open question. However, if a landlord is bringing frivolous court cases against a number of tenants in the same building, even if it's just, one per tenant across an entire building, that might be enough to satisfy harassment under this enumeration. So again, if you think it's not just you, if you think it's more than just you in your building, that might be enough to show, oh, wait a minute, I'm not the only one who my landlord's coming after in housing court. It's all of my neighbors. And that's helpful here. Illegal buyout offers. This can be as if you're negotiating a settlement or if a landlord is really pressuring you to move or leave or break your lease and is offering to pay you to do so, if you say no and they continue to ask you or put pressure on you to take a buyout, if you've made it very clear that that's not what you want, that can constitute harassment, because it substantially interferes with your rights to enjoy your leased premises. Another one that is that's very prescient is threatening an occupant or a tenant based on a protected class. That can be age, race, immigration status, sexual orientation, etc. That can cross over also into discrimination, which you can file a complaint with the New York City Department of Human Rights, but your landlord can't threaten you based on a protected class status. And that's been particularly of note recently with immigration status. It's important to know that a tenant does not need to prove that they are a citizen or have status to rent an apartment. Um, a landlord might be able to ask you for a government ID, but they are not allowed to force you to prove you're a citizen to rent to you. And that's very important. I can get into that also later if there are questions about that. And then,
Um, Sorry, Michael. I just wanted to ask, the exception will be for like NYCHA or subsidized to rent to you for certain programs,
the exception for which?
like certain programs, you may need to have a certain type of status for like NYCHA or
Yeah, so this is there are different programs, there are different requirements for this specifically. If you're going looking for a market rate apartment or an apartment, you don't have to prove your status for a market rate apartment. Thank you for that clarification. And that's we can get more into that later as well. But um for apartments that are not NYCHA, and Section 8 also has um some regulations as well. But for market rate or stabilized apartments, you don't have to prove that you're a citizen to rent. And then there's also a catch-all provision, and there's other enumerated conduct that it could go on and on and on and on and on, and it's worth reading. But there's also a catch-all provision, where if you think you're being harassed and the harassment does not fall under one of these enumerated clauses, then the Housing Maintenance Code also provides for other repeated acts or omissions of such significance as to substantially interfere with or disturb the comfort, repose, peace, or quiet of a tenant occupant, and that cause or are intended to cause the tenant or occupant to vacate or waive any rights. We'll go to the next slide. All right, so I mentioned before, as part of the case, proving the case of harassment, that there's an intent requirement that you have to show that the harassment conduct was done with the intent to cause you to vacate, the tenant or lawful occupant to vacate or surrender or waive any tenancy rights. Now, when you're bringing an HP case, the tenant does not need to show, except for these exceptions, the tenant generally does not need to show intent. If the tenant can make out a case to show that the conduct took place, that the landlord acted in such a way or the landlord's agent, and the conduct took place, and the conduct is covered under the Housing Maintenance Code, then that creates a presumption that can be rebutted, but a presumption that it was done with the intent to cause someone to vacate. The burden then shifts to the landlord to present a case to rebut this presumption and demonstrate a non-harassment reason for this conduct, or to show that they didn't actually act with this intent. And this can be shown in a number of different ways, generally with essential services or with repairs. The landlord can bring to court documentation and show that they were responsive to complaints by the tenants and that they sent maintenance staff immediately, that they tried to remediate the conditions, that they've been doing their due diligence, and they've been acting in good faith to try and make these repairs, but it might just be taking a little bit longer for some reason. So the landlord then has to show that these conditions or the harassment allegations were not done with this intent. So There are two notable exceptions in the Housing Maintenance Code and in case law to this rebuttable presumption. The first is that this rebuttable presumption does not apply to private dwellings, and those are one or two family houses or one or two unit um, buildings. So if you're, and we see this a lot in Queens, a lot of one or two family houses where there are fewer than 3 units. Um, Now, it's important to note the harassment law still does apply. Harassment is still illegal, and a tenant can and should still come to court to bring a harassment case. But if you live in a two-family home, the burden is on the tenant to show this intent. So you will have to show that the landlord acted with the intent to try and get you to leave. Um, Additionally, if you're only relying on this catch-all provision in the Housing Maintenance Code, if the harassment that you're alleging does not fall under one of the enumerated um, harassment clauses, you'll also have to show intent. And we can talk a little more later about what that looks like. Thank you. This is the owner of a dwelling shall not harass any tenants or persons lawfully entitled to occupancy of such dwelling as set forth in the Housing Maintenance Code. That's just showing that harassment is still prohibited by the owner of a dwelling. So it's not that you can't bring a harassment claim if you live in a building that's 2 or fewer units. You still can. Harassment is still prohibited. You just have to then show the intent. Go to the next slide. All right, so we're talking now about defenses to harassment, and we're giving, just broad overviews here. As I was stating before, so a landlord or an owner can show that the condition or the service interruption, for example, was not intended to cause any lawful occupant because they acted in good faith. They acted quickly. They provided notice. They did everything they were supposed to do. They acted quickly. They were responsive. They are acting in good faith. And when you file the petition, and we're going to get into what that looks like, then, as I was saying, the burden shifts on the landlord, and they'll have to provide this documentation to show that we're not acting with this intent. Go to the next slide. All right, so the penalties for harassment I laid out before, damages are a part of a harassment penalty, but, by and large, the most significant and perhaps important um, uh, relief that a tenant can get in court bringing a harassment case is the condition repaired. But getting the condition repaired can also be a part of a larger penalty for the landlord. So harassment is a Class C violation. It's a very serious violation, and a penalty can be imposed by the court, and the judge has broad discretion to find damages. I won't get into as in-depth of an analysis of calculating damages or seeking damages because that's a little more case dependent and is something that can be hashed out, in court as well. It depends on a bunch of different things. But in addition to getting monetary damages, your punitive and compensatory damages, the court can also issue a restraining order, or an order to correct, but essentially injunctive relief, restraining the landlord from harassing the tenant in certain ways and directing the landlord to ensure that no further harassment occurs. So it's not quite a restraining order, but it's a warning to the landlord asking them to stop the conduct that was alleged in the harassment petition. That can be really helpful because then you have an order that if the landlord breaches, you can come back and we can talk about contempt and what that looks like to enforce that. Additionally, a judge can can impose a civil penalty between $2,000 and $10,000 for each unit where harassment occurred. If there is a previous finding of harassment within the last 5 years, the penalty can be between $4,000 and $10,000. So let's just sit with this for a minute, because I mentioned before the importance of talking with your neighbors. This is another area where you don't have to go through this alone. It is unlikely, like I was saying, that one individual tenant, especially in a large building, is the only apartment dealing with these kinds of issues. We're talking about penalties of between $2,000 and $10,000 for each unit where harassment occurred. And you can do the math. If you have even 10 or 15 units in a building, those penalties can add up and can be quite a deterrent against the landlord for harassment for harassing in the future. Finally, HPD has to post the harassment finding, the landlord's name, the penalty on its public website within 90 days of the finding of harassment. And something that we're trying to work on in Queens in general is creating a better database, just a more easily searchable database for tenants of landlords that have been found to have harassed or found in contempt and so on. One quick note on damages, there are statutory damages that a court can impose of $1,000 or $2,000. A tenant can opt to take an award of $1,000. But judges also think about compensatory damages in terms of an abatement. So if a court finds that there was harassment that was ongoing, a court can do a calculation of the value of the apartment based on the lease and the value of living in your apartment, and can calculate how much the harassment impaired or reduced the value of living in the apartment. And that can be a percentage amount. And that there are charts and there's case law of specific different kinds of conditions, how long a condition has been going on, the severity of the condition, what the tenant had to do to remediate the condition. So there's calculations that go on if it's a 2-bedroom apartment and 1 bedroom was unusable, so that's a different question. But there are penalties and there are damages that tenants can seek with harassment petitions. We'll go to the next slide. And this is going over these are some cases which we can get into maybe at a different training, but these are just some cases. Like I was saying, it's kind of a very fact-specific and case-dependent analysis of what the damages amount will be. And it also depends on the judge as well. Some judges are more quick to award damages. Others, think just getting the condition repaired is what's important, and the civil penalties aren't as important. So it's case specific, but it's important to just know when you fill out the petition that it's worth seeking damages, because it's worth just including that in the petition because those are available to you in addition to getting the conditions repaired. We can go to the next slide. All right, so before we get in,
right, with this part, just a quick, I don't want folks to get too excited about winning a huge, award like $10,000, because they win that because they suffered for a very long time.
Yeah,
we'll get back to that.
Yeah, thank you, Patrick. I guess that is a fair point. The damages are few and far between in harassment cases, and as Patrick was saying, the damages on the higher end are for extreme conditions that are close to, if not displacement for months, if not years. Displaced because of a fire, really uninhabitable. So it's for conditions that don't quite rise to that level, damages is not it's possible, but not likely is I think the current state of things. But it's important to just know that you can include it in your petition. But it just might not be they might not be awarded in a way that perhaps might seem fair, but that's another question. Just put this in here, I think filing an HP petition, and I think the next slide is going to talk about filing an HP versus waiting to be sued. Judges have, if tenants have filed numerous HPs over the course of a few weeks or a month, and they have all been dismissed or found to be lacking merit, some judges have enjoined tenants and prohibited tenants from filing future HPs. Basically, the tenants shouldn't be filing frivolous lawsuits against landlords, and so some judges will do that. We can talk about what this is as well if people have questions about this. But just to be known that there have been some cases where judges have found frivolous HPs and have stopped tenants from bringing HPs for some amount of time. So we'll go to the next slide. Thank you. All right. So we'll talk about what it looks like to plead harassment. So there are a few different ways that a tenant can raise a harassment issue in housing court. Before I joined the housing group advocacy team, I practiced for some years doing eviction defense. So I defended tenants in housing court who were facing eviction and were being sued by their landlords in either non-payments or holdover cases. And when you're being sued in housing court, the tenant files an answer. That's the responsive pleading to the landlord's petition. And in the tenant's answer, you can raise harassment as a defense and as a counterclaim to whatever the landlord is alleging. If it's a non-payment, for example, where the landlord is alleging that a tenant owes rent, in your answer, a tenant can raise harassment to argue for an abatement that, well, the rent that is being sought, I don't owe because of these conditions. And that can be a tool to argue for an abatement and to reduce the amount of rent that is allegedly owed. It can also be an effective tool in a non-payment or a holdover case, and you can also in a claim in supreme, in a non-payment or holdover, because a harassment counterclaim can survive after a case is dismissed or discontinued. So I'll say that again. You can have a non-payment case dismissed or discontinued and have it be over, but reserve a limited hearing just on your counterclaim issue. So this is significant, and this does take some fighting, and this does take some advocacy to the judge because judges will will more likely just try to dispose of the whole case at once, but you can preserve your counterclaims here. So if you're being sued in a housing court case, just know that harassment, you don't have to wait to come back to court for harassment. You can raise it as a counterclaim and as a defense. From there also, there's retaliatory eviction and other defenses that can be part of a defense as well, but that's something important to know that this, I'll be focusing mostly on going to court in an HP where a tenant sues the landlord. But it is important to know that if a tenant finds themselves in housing court being sued, that harassment as a counterclaim is available. And in raising, just like it is in an HP petition, a harassment counterclaim and an answer needs to be very detailed and very specific and needs to follow the same elements that we talked about before. But this is just an important tool to keep in mind that it can be a way to fight back when you're on the defensive. Now, pleading harassment in an HP. So an HP stands for housing part. And this basically is a way for tenants to go to housing court and sue landlords. And HP actions can seek orders from a judge to stop harassment. Not as much for damages or destruction of personal belongings. You can go to small claims court for that. But really, the benefit of an HP is that you will likely be heard more quickly than an answer in a non-payment or a holdover. And you can seek as early as your first court date an order to correct or an order from a judge ordering the landlord to make repairs and granting access dates. So it is a much quicker vehicle for getting these repairs and these issues addressed than waiting to be sued in a non-payment or a holdover. Go to the next slide. All right, so when we're talking about starting an HP case, what does it look like? What does a tenant need to do? What should a tenant prepare? What does it mean to plead? So the way that before you start an HP case, it is important, not essential, but important. And I would strongly encourage gathering as much evidence as possible. Judges want to see specificity in pleadings. So while it is enough to say my landlord is calling me names and is shutting off my lights, that does fall under the Housing Maintenance Code definition and enumeration of harassment. It is much, much stronger to come to court with evidence and say, on December 12th, 2025 at 6:45 a.m., my landlord was pounding on my door, and here is a recording of them pounding on my door, timestamped at 6:45 a.m. Here are text messages with dates on it of things my landlord has said to me. Here is a video that I took on December 1st, 2025 at 3:45 p.m. of my landlord shutting off the circuit breaker to my apartment and shutting it back on and shutting it off. So being as specific as possible will really, really help demonstrate to a court that the severity, and also will help the judge issue the order to correct. Government records are also vital to have before you come to court and before you file the petition. These can be records from HPD, DOB, violations, inspection reports, which you can find on HPD and DOB's website. These are really useful tools to come to court and show the judge, look, here are all of these violations. I'm not making this up. This has been, a government agency has found these violations. Take that what you will. And a court will give tremendous deference and find judicial notice of government records and government reports. So that can be very, very helpful. I've seen judges, as we're in the HP hearing, go onto HPD's website, as we're in front of the judge, search up the building and look online for these reports. So these carry a lot of weight with judges, violations that have been placed. I'll also say, a police report can be helpful. I think there are other thoughts and other considerations before going to the police, especially for harassment. Police aren't always necessarily the most helpful with housing issues, and that can be also tricky just in general dealing with police. There are a lot of reasons why tenants don't want to deal with police or invite police over to their apartment or their homes, but a police report can also be helpful if that's something that you have available to you. So gather evidence, gather documents, and then armed with all of your evidence, armed with all of your text messages and dates and times, go to housing court in your borough. In Queens, that's at 8917 Sutphin Boulevard in Jamaica, and go to the clerk's office. It's room 209 in Queens, and you can find this information online at the different boroughs as well. Go to Housing Court Answers. They will have this information as well. And you tell the clerk that you want to start an HP action for harassment. That's again, housing part, HP action for harassment. And they will give you an order to show cause and other forms. And we can show this later, what that looks like, the order to show cause form. And they'll give it to you, and there will be spaces marked out for where you should fill in and what you need to fill in there. You can also request in housing court a fee waiver form. It does cost, I think, $45. Patrick, correct me if I'm wrong, to file a petition and get an index number in housing court, but there are fee waiver forms that you can request and fill out. You can also request in housing court an inspection request and fill one of those out as well. But you go to the clerk's office and say, I want to fill out an HP action for harassment, and fill out an order to show cause. The clerk will give you a piece of paper, the petition, and the order to show cause. That will be clear. It'll say, write your name here, write your landlord's name here, write your address here. And then it'll say, there will be space where it will say, please state the reasons, or state all of the harassment, state the reasons why you're being harassed, essentially. And in that space is where you'll be able to, handwrite and so on and so forth. There's also space that says list all the things that need to be fixed in your apartment, write your violations here. It's self-explanatory what you need to fill out and where, and you'll fill out all the information. You can be as specific as possible in the pleadings if you have the dates and times, and then you'll have that petition. And if you request an inspection date, you'll get an inspection date if you requested one, and then you'll also get a court date, usually about within 10 days of when you file. So that's a much quicker turnaround than other types of court cases, usually because the repairs are very urgent and the court takes very seriously these conditions. Very importantly, and the clerk will give this information as well, and it's also on the petition, the tenant needs to serve the forms on the landlord as soon as possible by certified mail. Again, the tenant has to serve the forms on the landlord as soon as possible by certified mail. If you do everything perfectly, you have all of your evidence, all of your documents, you write out a summary and a description of the harassment, and service is improper, as soon as you come to court, that's going to be the first question the judge is going to ask. You have proof of service. If you don't have proof of service and service wasn't proper, the case will be dismissed. And it would be a real shame and just very frustrating if the case is dismissed for improper service. So there are forms at the court as well for how to serve properly. But if you have to know your landlord's name and address and serve via certified mail and keep copies of everything. And the clerk will give you copies to send to serve as well. Okay, so you come to court, you fill out the HP petition, order to show cause, you serve it properly, you get a return court date. You show up in court. Now, if you don't have a lawyer, there will be a lawyer from HPD in the courthouse who you can talk with and who you can ask questions, and you can kind of, show them the violations, and they'll usually be able to talk with you and kind of work with you to make sense of this is a class A violation, class B, class C. The court and the judge is going to make sure that the service was proper. And if the landlord doesn't show up, you can potentially ask for a default judgment and so on. But if both sides are there and the landlord shows up, then the court really will encourage both parties to try and settle. The courts love settling cases to get it off of their calendar. And a settlement could look like providing access dates to repair a broken light bulb, or to remediate mold, or to fix, a leaking toilet. Providing access, the landlord agrees to show up on a certain date at a certain time with workers, 9 a.m., workers to arrive by noon. And that is a possible way of resolving an HP case before going in front of the judge. You just settle it. If you can't settle, and different service providers and different people have different ideas on settlement, I think personally it is worth going in front of the judge if you can, because you can show the judge, look, there are these very serious conditions. There's also always the chance that, maybe you missed a violation, and the judge can look in HPD's website and see all these other violations. The judge can help also encourage access and issuing orders to correct. And that also can keep the case on the court's calendar, and the judge can help you say, okay, here's the order to correct. If the conditions are not remediated by this date, then we'll have the next court date and we'll come back and, we'll talk again and see what happens. If you can't settle on that first court date and there's no order to correct, then the judge may adjourn the case and schedule another court date for a hearing. And that's going to be the time when you'll have to present. You should come to court with all of your evidence in general, but at the next court date, you'll have the hearing, and that is where you'll have all of your evidence and you'll present it to the judge. The landlord will have the opportunity to make their rebuttal and raise their defenses. But at that first court date, you can really try and get the conditions repaired. If we're talking about conditions, if we're talking about, threats or other kinds of behavior, then, you can work with the judge to try and figure out and ask the judge, to issue an order stopping your landlord from doing those things. So it's helpful to advocate before the judge, I think, and the HPD attorney. So our slide here, pleading harassment, like I was saying, you want to be very, very specific when you plead it in your order to show cause. Dates, times, names, have your proof ready. I think that's, with NYCHA buildings, it can be kind of different because you might need to serve notices of claim, but generally you want to be as specific as possible. Next slide. And importantly, like we talked about, there are a lot of landlords where it's not individually owned, but is owned by an LLC or a corporation. The LLC and a managing agent can be held responsible for harassment. It doesn't just have to be from the landlord or the person who collects your rent. The actions of agents are imputed onto the owner of the building. So just because you've never met the owner of a building or don't know who the LLC is, doesn't mean they can't be held responsible for the actions of one of their agents or employees. Tenants can also bring harassment cases, even if there was a previous HP case for the same conditions. If the conditions were not remediated, or if they came up again, come right back to court, get another order to correct, and you can bring them right back. Wouldn't be frivolous if there is a condition that's there. Um, Harassment can be difficult if the harassing conduct is caused by a fellow tenant. If you remember, the harassment statute is talking about harassment that is caused by a landlord or someone acting on behalf of a landlord. That line can be blurry. Tenants generally don't act on behalf of a landlord. Um, there are cases where supers are also tenants, and that can kind of blur the line a little bit. But in general, you know, courts are reluctant to find that a tenant has harassed another tenant under the Housing Maintenance Code, because it's not contemplated by the statute. But as I was saying, if the other tenant is acting on behalf of the landlord, harassment could apply. There's a super, and so on. So pleading for harassment, you can go to the next slide. Thank you. So pleading harassment in the HP part, like I said, you go to your housing court in your borough, and there are different parts, part H, part B, it's part C in Queens. Just go to the clerk's office and ask for an order to show cause and for a harassment petition. It can be very confusing. Housing court can be a confusing place, but go to the clerk's office or the help desk and just let them know why you're there, and they'll be able to help you, figure out where you need to go and what you need to do. You're not going to see the judge on the first day you go to court. You're going to fill out the paperwork and serve it, and then you come back to court. So it can be helpful to just think of that, one step at a time. There's some miscellaneous notes here. Tenants can sue for harassment for the absence of conditions, if there's an essential service that a landlord is supposed to provide and they are not. If there's a benefit in the lease, or if there's a part of your lease that you signed, like a common space or a recreation room or some kind of a perk or a benefit that you're paying rent for, and that benefit is not being provided to you, that potentially could constitute harassment. So it's not just something that is there, it can be something that should be there but isn't, if that makes sense. And again, getting an order to correct, especially for conditions, is going to be your goal. And even if the judge dissuades you on the return date from trying to get the order to correct, you should really try and push the judge. And you can have the HPD attorney can sometimes help with this, at least of getting an initial order to correct before the next court date, because that can be independent of whether or not there is harassment. If there is a condition that is in the apartment, it should be corrected as soon as possible. And judges generally will not give too hard of a time with that. Although, again, judges can be very temperamental. We can go to the next slide.
Let me just go back real quickly.
Yeah.
Okay. It's okay.
Yeah.
Oh,
Again,
Michael, you said notice of claim twice, and HPD. You wanted to say what HPD is and what a notice of claim is, in case people worry.
Notice of claim.
Who is HPD? Just in some case anyone doesn't know what HPD
is. So HPD is, there's an HPD attorney, and that is the city agency that is required for enforcing the Housing Maintenance Code and for inspecting conditions in apartments, and for dealing with harassment and for dealing with issues of warranty of habitability. So the warranty of habitability is it's a statutory right that all tenants have. It's implied in every lease and every landlord-tenant relationship. Landlords have an obligation to maintain safe and habitable living spaces for tenants, safe buildings, safe apartments. That is not a right that a tenant can waive. And HPD is the city agency that is in charge, among other things, of enforcing the warranty of habitability. So they are required to inspect the premises if there are alleged violations or breaches of the warranty of habitability. And they, in housing court, I say HPD attorney, there's an attorney in the HP part from HPD who represents HPD in these HP cases and can work with tenants if they see there have been violations imposed by HPD, they're responsible for basically, making sure that if there's a violation, that it gets remedied. Patrick, feel free to add more if you want, but HPD important doesn't they're neutral on whether or not there was harassment, but they can um, explain it to the judge. I think it's also important that there are other legal service providers in court. HPD doesn't work for tenants or for landlords; they work for the city, so they won't necessarily weigh in on whether or not there is harassment, but they can help. They can provide documents. They can provide notices of inspection. They can provide important information to the court as well. And sometimes HPD attorneys will discourage damages and will just worry about getting the violations repaired. Um, they can participate in the trial as well, but HPD is the city agency that helps tenants enforce the warranty of habitability. It's a very simple way of thinking about it. There are other things that they do, but specifically for harassment, that's their role. Um, so, if as we're going through and thinking about harassment based on conditions, you know, and we can go to the next slide here. Um, and this goes again also talking about HPD. The most important thing that a tenant can do is report the conditions, even if violations aren't always placed. So calling 311, when you call 311 and you say, I want to report an unsafe condition in my apartment, I want to request an inspection, then that lodges a complaint, and then HPD will send out an inspector to contact you to take a look to see if there's a violation that they need to place, and if there's a violation that needs to be placed, they will place the violation. And that can be helpful coming to housing court and have the judge take judicial notice of. You can also request a judicial inspection, which I'll just say as best practices, calling 311 is always a good idea. I won't say always a good idea. 99% of the time, it's a good idea to call 311 and have an inspector come out to take a look at a violation and at a condition. There are certain circumstances which we can get into later when it might make less sense to call 311 or look for a judicial inspection or request a judicial inspection. There have been cases where judges will personally go to apartments and inspect the premises themselves, but these are, fewer and far between and not as much the norm. We can go to the next slide here. If there are many violations and complaints on a building, the judge can theoretically take judicial notice of all of the complaints and violations, even if they're not specifically for your apartment. So that's also something to keep in mind. All right. You went to housing court, you had a judge issue an order to correct on your HP, which means that the judge found there were violations, and the judge has ordered the landlord to correct the violations or the harassment issues that had occurred. So the next step is for the landlord to comply with the order to correct. So it's very important that the judge will then try to have the order to correct be the last part of the case, and then say, okay, this case is over. Here's your order to correct. This is what you wanted when you went to the housing court. You have your order to correct here. You established through your testimony at the hearing that there are violations. Here's your order. I'm ruling in your favor, which is great. We want orders to correct. What we don't want is for the judges to then take the case off the calendar, because let's say your landlord does not comply with the order to correct, then it is a lot harder to restore the case. Not impossible, but it is easier if the case is still on the calendar. When the case on the calendar means that it's not over, that there's potentially another court date, or that there is another court date to control for if the landlord doesn't comply with the order to correct. There's already a date on the calendar. You can come back to court and tell the judge, look, they didn't correct. It just makes things a lot easier. If the landlord did not comply with the order to correct, then you can bring an order to show cause back in housing court for contempt. And contempt is the mechanism by which you say, a tenant can say, a landlord was supposed to follow the judge's orders. The landlord did not follow the judge's orders. So I need some more help. Um, Proof is essential here as well. Make sure you read the order to correct. Um, there will be dates and times and requirements that the landlord has to comply by. Make sure that you have proof that the landlord did not comply with the order to correct. Contempt, you can also seek damages for contempt, but really it just is a way to come back to court and ask the judge to reinforce the order, seek damages, seek penalties, and try and turn up the heat on the landlord to comply. Um, if there's still, potentially if the landlord does comply with the order to correct, and then there's additional harassment that comes afterwards that's unrelated to this case, sometimes judges will entertain it, but more likely than not, you'll have to go back and file another, order to show cause in HP. Now you can say, and you can point to this other order to correct and bring that to court and use that as evidence to show that there was a finding of harassment, that this isn't the first time. And that might, you know, weigh in your favor if you're contemplating damages and so on. But in general, the order to correct is what you want when you go for an HP. It will say, here are the list of violations. They must be repaired or remedied by this date. The access dates will be on this day, and you'll be able to work with the judge on when to provide access. But talking about access, something that we sometimes run into is, people work during the week, Monday through Friday, and providing access for workers or maintenance to come into the apartment can prove difficult if generally a judge will order workers to arrive between 9 a.m. and 5 p.m. to arrive by noon. If you work and if you can't miss work, or if there's nobody who can be in your apartment to provide access, you can talk to the judge and you can try and work with the parties to figure out a way to get the repairs remediated, because that shouldn't be a barrier to getting these repairs done. And that's something to also just keep in mind, that a judge may put pressure on you to say, oh, can't you just miss a day of work here? Can't you just miss a day of work there? If you can't, you can be respectful and you can talk to the judge and say, I'd really prefer an alternative. Perhaps, I've seen this done. It's rare. Perhaps the workers can come on a weekend. But you can advocate for yourself here. If you're at the point where there's an order to correct, there are violations, they're going to get repaired, but you should feel free to advocate for yourself when you can be comfortable letting someone into your home to make these repairs. That's also just a very important point. The tenant bears the burden to prove that the repairs weren't done. And, the landlord generally will come to court for, to provide proof. I paid a contractor here. We did this, we did that. I've been reaching out for access, but the tenant wasn't home. We were here. Here's a picture in front of the unit at the time. So it's a fact dependent hearing, but that's generally, that's generally the way that contempt units would go. All right, we can go to the next slide. So there are just here some difficult circumstances. I mean, these are also pretty fact dependent. There are civil penalties that contemplate if the landlord is making false certifications or misrepresentations to HPD or DOB, and DOB is the Department of Buildings. There are civil penalties that can be assessed. If there are ongoing conditions, so even if the landlord has made the repairs, but then the repairs, but then the repairs or conditions exist within, the next 6 months. This is very common with roach and mice infestations. If there's an infestation of roaches or mice and the exterminator comes and places traps and exterminates, and then, 1 month later, the roaches are back. That's another call to 311. That's another inspection. That's another violation. Assuming your landlord isn't going to come back and make those exterminations again. So don't just because the order to correct was issued and the conditions were repaired, if that condition comes back, you don't lose any rights to go back to housing court for that new condition if your landlord's not gonna fix it. Um, One other note that I'm thinking of, in the context of raising as counterclaims or seeking rent abatements, um, another thing the landlord can argue or show, and this is mostly for raising as a counterclaim, if you're seeking a rent abatement, which is where you're asking the judge to reduce the total amount of owed rent based on the violations of the warranty of habitability, devaluing the premises or making a part of your premises unusable. If you can't use 25% of your leased premises, your rent should be reduced by 25%. That's what we're talking about, an abatement. You'll have to show that the condition was not caused by the tenant and that the tenant gave the landlord a reasonable notice and reasonable opportunity to repair the condition. So you have to give the landlord some opportunity to try and repair, and reasonable varies based on the severity of the condition. So if it's a very serious condition, reasonable notice could be 24 to 48 hours. If it's something like contacting an exterminator, if you let the landlord know and they say, okay, I'll reach out to an exterminator, they call that same day. They say the earliest the exterminator can come is 5 days from now. It's an open question over whether or not that's reasonable, but that's what we were talking about. You have to show the tenant didn't cause the condition, gave the landlord an opportunity to repair it, and then the violation or the condition was not repaired. For construction, so major, work to the building, or building-wide work, electrical, roof work, scaffolding, things like that. Elevator violations also weirdly goes to DOB, not HPD. These are also important things to think about and can constitute harassment. But it is a little bit more difficult. HPD is not going to be involved, and they're going to kind of shirk responsibility. And so going to the Department of Buildings is going to be a little bit, a little bit more circuitous, but also important. We talked about earlier, sporadic conditions such as hot water, heat, electricity. HPD doesn't come out right away, and I'm not looking at the chat. I'm going to anticipate already questions like, I called 311, they never came out, just because we see this all the time. Called 311, inspector never came. What the heck? That unfortunately does happen, and sometimes you'll have to call again, and I'm going to assume that's a question. We can get to that later. If not, I'll talk about it anyway. But if HPD doesn't come out right away, if you can take a picture of a thermometer, if you don't have heat in your apartment, that shows that it's 55 degrees in your apartment, or it's 45 degrees in your apartment, and take a picture of that, that can be helpful evidence. Testimony, you know, circumstantial evidence as well can be helpful. Holes in the floorboards that look like mouse holes, bug carcasses on the ground. If the circuit breaker is locked, you can take a picture of the lock. You don't have a key to it, so you clearly couldn't have turned the electricity off because you don't have access to it. Mold is another serious condition that courts do take very seriously, and that's also one that we see quite a bit. Sometimes landlords will try and just paint over mold for black mold conditions. We argue that that's not sufficient, that's not adequate remediation. And so that's also something that can be a little contentious. There's some stuff in here, during COVID, there were more remote trials and remote inspections. It is important to remember that tenants can request virtual hearings. If you have a disability or an accessibility issue and can't make it to court, you can put in a request for a virtual hearing and a virtual HP. And courts will generally accommodate that if a tenant makes that request. Experts are difficult to come by. That's something that our office struggles with sometimes. We've had cases where, there have been some highly technical plumbing issues or like HVAC and air conditioning and heating issues that would be great to have an expert, come in and testify on. That's just hard to come by and very expensive. Access is very important. Tenant has to provide access. If there's an order to correct, you have to provide access. Refusing access is going to make it extremely, and I cannot stress this enough, extremely difficult to prevail. Certainly on contempt. But even if you get an order to correct, if you don't provide access, it's going to be very hard to restore the case. It will make it extremely difficult to prevail on a counterclaim for harassment in a non-payment or a holdover or a trial. If you didn't provide access, it just there's not much the court's going to do to rule in favor of the landlord, unless there's a good reason if you were in the hospital or if you were incapacitated. But those are again fact specific. We go to the next slide. Settlement negotiations. Harassment is a very useful legal mechanism to get an order to correct and get conditions repaired. It is also an effective legal mechanism to negotiate a settlement in a non-payment or a holdover case, and also in harassment HP cases. In the context of a non-payment or a holdover, like I was mentioning before, if you have a fairly strong harassment counterclaim where you're seeking damages and you're seeking a rent abatement, a landlord might not want to go through the risk of trial and pay their attorneys and go through the time and the cost of litigating. They may be willing to negotiate an abatement with you. And that's something that, if you are represented by an attorney can help you with. But these are just some considerations as you're settling. If you bring a harassment claim, but you've denied access and wait a minute, this might not be the strongest claim, that might there are different considerations to this. If the tenant was if the landlord was saying, well, the tenant's been nasty to me and has been doing all this, there are just different considerations. How strong is your proof? This is huge. If you can show the landlord all this proof that you have, these are the violations, and it's fairly certain you're going to prevail, that can be very strong. So, these are mostly for lawyers and for attorneys, sort of understanding the pros and cons and negotiating settlements, but also for tenants. These are just important things to keep in mind. You know, if the judge is encouraging you to settle, is it worth, if your landlord is willing to just, go tomorrow and repair these conditions, okay, maybe you'll drop the, damages because those aren't really that likely to prevail anyway. And it can be used as a tool to negotiate a settlement. And in non-payments and even holdovers, but non-payments, it can be used as a settlement tool to reduce the amount of arrears, which I've done in my practice as well. I think we can go to the next slide here. I think we can also skip this one as well. This is mostly for,
Michael,
yeah.
it's like 3:20. I think if you get to 3:30, you could start, maybe want to ask.
Sure. I'm getting to the end here.
Yeah. I know you are.
So
Just give you a heads up.
thank you. I appreciate that. We talked about this before. This is the way that the landlord would have to rebut harassment claims. We can go to the next slide here. This is also, we can skip this one. This is just, we talked about as well. And we're going to share these slides as well at the end. Actually, what, Patrick, you can go back. I'm sorry to be skipping
you might
past
like
here.
this one.
This is an important slide. This is the evidence that I was talking about before, and we're going to share the slides. Pictures, text message, emails, recordings, letters. The line at the end, recording without knowledge is legal. New York is a one-party consent recording state, which means that you can record conversations as long as you're consenting to being recording as well. You can subpoena. You don't need an attorney to do this. You can subpoena HPD to ask for, basically, it's a request for information. Subpoena is a request for written documents, or sometimes for someone to come to court and testify from HPD to see if there are other documents about conditions or violations. Vacate order information, and we can share also resources. There are some great websites where you can put in your address and see all of the conditions that are available. Rent reduction orders, you can look at files of previous housing court cases, talking with neighbors and families and roommates. These are evidence, can be testimony, it can be oral testimony. You can talk to the contractors to see if they really were contacted. You can be creative with collecting evidence here, and looking up complaints as well. And yeah, who owns what is the name of a website that you can put in your address. You can Google your landlord. Quite often there are landlords who are in the news for conditions. You can use, newspaper articles and so on. And we can go to the next slide, Patrick.
Can I make one pitch on reduction in service complaints to DHCR? And if you get a rent reduction order, I like using those because it's a 2-page form. You don't have to be an attorney to do it. You get the form off the website. It's like RA 81. The inspection reports are usually really good, and the landlord will either make the repairs or you're going to get an order saying the landlord did not make the repairs and your rent's reduced. And I like that as because it's really tenant friendly. So yeah, Housing Court Answers knows this well, and you can work with them or any of your allies. But you can always email Michael, and we can help you with the form. It's really easy to fill out.
And I think you can go to the last slide because the rest of is
Okay.
mostly for attorneys kind of litigating damages, which
Yeah,
is
okay.
you can keep going to one more, and then this will be the closing thoughts. So a few closing thoughts before we open it up for questions. And we talked about harassment as leverage. We talked about negotiations. I want to reiterate again the value and the real power that can come from talking with your neighbors. That this can feel like a very individual. It can feel really awful if your landlord is harassing you, if anyone's harassing you. But if your landlord is harassing you, it can feel really awful and terrible and can make you feel unsafe in your home. And there are all the negative elements of being harassed. Talking with your neighbors, setting up a tenant association. In New York, tenants have the right to form associations and have meetings in public areas and common areas of the building. Um, Talking about tenant harassment and joining together and filing group HPs can be a very effective way of taking some power back, making it feel a little bit less overwhelming. And, the Legal Aid Society's practice and other practices as well specifically represents tenant associations and groups of tenants and HPs. That is part of our practice. So, if you think you yourself or other tenants in your building might have these issues, please reach out to us. We have our colleagues Joanna and Zoe's emails at the bottom of this, but we'll put our information out as well here. Elected officials, if there are any representatives from elected officials here and constituents are going to them with issues about harassment and building conditions, please reach out and encourage tenants to, form associations and talk with neighbors. This is protected activity under the law. And there are very serious anti-retaliation statutes. A landlord cannot sue. A landlord can sue you, but it's a defense that a landlord cannot bring a lawsuit specifically to retaliate against a tenant for forming a tenant association, or really for bringing harassment to. So I would really just close with talk with your neighbors. You know, Going to housing court can feel overwhelming and scary. You can go, it is designed for tenants, at least in HPs, to file pro se. The court could be better at navigating, for individual tenants navigating, but the harassment can be a very effective tool in getting conditions repaired in your apartment and for deterring your landlord from continuing. So talk with your neighbors, happy to answer questions. Yeah, thanks everyone for being here.
Thank you so much. That was a great presentation. So I think some of the questions were answered, so I will be moving on from those, and then we'll just go over on a few questions, and you just let me know when you have to stop. Um, so you can hear me, right?
Yes.
Okay, perfect. So somebody said that they needed repairs on their unit and they filed HP action with harassment and housing court, but housing court staff personnel vigorously discouraged me against filing with harassment, but I did anyway. And then the judge denied their filing my HP case with harassment. Do they need an attorney? So just remember, we can't ask a case specific questions. It should be general, but this may be general. Okay.
Sure, I can give a general answer to that. Yeah, without more specific, I think unfortunately some housing court, I don't know what borough this was in, but some housing court staff, our offices have, well, legal service providers' offices have complained to the courts where sometimes staff are discouraging to tenants. I think you have a right to file in housing court. You have a right to bring complaints and seek orders to correct. I'd be curious to know what the basis was for the judge denying the HP case. It could have been for improper service. It could have been for a number of reasons. So usually when the judge denies it, they would tell you the reasoning. So if it was for improper service, the judge would say, service was improper here. And thank you, Patrick, for sharing this. So this is when you go to housing court, at least in Queens, you'll get this. This is the sample HP petition, but you fill out one of these forms. But sometimes it takes, an advocate here. And I will say in Queens, the legal service providers have offices in housing court, and frequently we'll have tenants come in with exactly in the situation that question was, where they'll have an HP petition that was denied, and they'll say, "What the heck is going on?" And usually, not often, and I can't speak to whether or not they'll be able to get an attorney. Usually, someone will be able to look at it and say, "Oh, the judge said you didn't serve properly," or the judge said you missed the court date and defaulted. So. Um, yeah, that's generally, but I'm sorry that they were discouraging to your trying to bring a harassment claim.
Right. So this was already answered, but I'll just repeat it so everyone can know about it. You can bring a witness to your HP action court date. Somebody had asked that, and that was answered. And somebody asked if squatters count, and the
Okay.
answer is
Oh,
no.
just a second. Patrick, we're seeing your emails.
Oh, sorry.
Yeah. Oh, the email I sent out just now.
No,
Yeah,
no, we're
it's
seeing your email
seeing
on
your
your
You're still
screen.
sharing?
My bad. That's my bad. Let me end up. So I just shout out the sample HP, but I see what Michael thinks, but I think a squatter probably is not a legal occupant to bring, it's almost any occupant can bring an HP, by the way.
So yeah, I will say there is case law. A squatter does not, I don't believe meets the definition of lawful occupant, because kind of by definition,
Yeah.
they're not there with the permission to be in the premises. But again, like everything, it depends. Depending on how long they've been there, if the landlord knows they're so it. I don't think a squatter is a lawful occupant for the housing maintenance code. Um, but I'd be open to being proven wrong.
Yeah. I mean, yeah, go
Also,
ahead.
maybe like just briefly, we can explain because like some people think a squatter is the same thing as a licensee. Maybe briefly just explain the difference.
Sure. Well, a license. So there are tenants, and a tenant is an occupant of an apartment that has a lease. The name is on the lease. There's a landlord-tenant relationship. A licensee is someone who is occupying an apartment with the permission of the tenant, or with the permission of someone who has that rights to the apartment. So a licensee is someone who has the right to live there. A classic example would be in a rent stabilized apartment, a tenant of records, child. The child would be the licensee if the child's not on the lease. They're still able to live in the apartment. A squatter is someone who is um, in an apartment or in a dwelling unit that doesn't have permission to be there, either from the owner or the landlord, and is just occupying the unit itself, to put very, very broadly.
Yeah, I think sometimes people think like, oh, the lease expired and now you're a squatter. I'm like, yeah,
No,
no.
that's a very good point. So, and I also see in the chat that Sarah's right. Lots of people get called squatters who aren't actually squatters, though. These are legal terms with legal definitions, and just because if you stay over, if you hold over, and a holdover is when your lease expires, but you're still living in the apartment without a lease. That doesn't automatically turn you into a squatter. It things, it depends based on the lease and the restriction, but generally you retain your tenancy rights. If you're a tenant, just because your lease expires, you continue to be a month-to-month tenant in general, and there are different circumstances there. I'm happy for other questions too.
What are implications to building management if there's a finding of harassment beyond money?
What are the implications? Yeah.
Yes.
The implications, if there's a finding of harassment, well, so beyond money, well, I guess if the court finds that there was harassment, then that's where the order to correct would come in. And so just like, in a case, a judge can issue a decision, like dismissing a case or, ruling in favor of one party or the other. The order to correct is the judge's finding that there is harassment. The judge has found these are the conditions that exist. There are harassment, and the landlord must take this corrective action, usually repairing the conditions or stopping from behaving in certain ways. So if the judge finds, for example, that let's say your landlord every morning at 3 in the morning is banging on your door and is calling you names, and you open the door and they're gone. They just do it for 1 minute every morning, and they just wake you up at 3 in the morning. A judge can issue an order to correct, saying the landlord may not do that anymore. They cannot behave like that anymore. So money is civil penalties and damages, but a landlord may also be enjoined, which means stopped from doing something. And as far as implications, if a building or a landlord has a bunch of violations and a bunch of harassment claims against it, the Attorney General's office may investigate the landlord, may investigate the building. There are other potentially, high penalties, not just monetarily, that a landlord may face if they are chronically negligent or chronically, finding that tenants are being harassed. So that's why it's worth it to make complaints to thrown on HPD, because the more violations that accrue, that's just more leverage, when you go to court. For what that's worth.
Uh, I would say if there is an order like, hey, stop banging on the door and it's happening at the moment, do you think it's worth it to just call the police and show them the order and be like, hey, he's still continuing? Is that maybe a strategy you would consider?
It is a strategy. I'll give the same caveat before with calling the police. Generally, at least in our experience, the police aren't great with housing issues, and they'll just say, go to housing court. But, I mean, criminal courts have orders of protection and restraining orders, which is different than housing court. Housing court is civil. But if if you feel comfortable calling the police and that is something that you're okay with, then you can call. If you show them, you know, assuming the landlord is still there, the police can come. But if the landlord leaves, the best they can do is give you an incident report. But the incident report is going to just be based on, if they don't see it happening, is going to be based on, the allegation. So that's why we say it's generally better to record it just so that you have the proof of it. And then you can call the police once you have the recording. But the police generally aren't going to do anything. They're just going to say, you got to go to housing court anyway, for what that's worth.
Great. Another question that was answered, I'll just repeat it so people are dialing in can know. The HPD lawyer is neither for the tenant or the landlord, but their job is to enforce the law, and the tenants are essentially doing their work. So in essence, they assist the tenants. So yeah. Let's see. Is withholding or refusing to renew a lease considered harassment, especially if the withholding began after the tenant started an application for scree?
Um, I assume this is the landlord withholding or refusing to renew a lease. So the answer that I'm going to give to all these questions is it depends. But so for rent stabilized tenants, and we didn't really talk about rent stabilization in this training as much, but under the rent stabilization code, rent stabilized tenants are or rent stabilized landlords of tenants in rent stabilized buildings are required to issue renewal leases at the expiration of a term. There are mechanisms with DHCR where a tenant can file a complaint to DHCR saying my landlord was supposed to give me a renewal lease and they didn't. Again, with this question, I'll refer us back to what we talked about, what we have to prove to satisfy harassment. There has to be an act by a landlord or a landlord's agent with the intent to cause you to leave or give up one of your housing rights. So if they're just withholding your or refusing to renew your lease, I think there's an argument to be made. I mean, if you're rent stabilized, you can go to DHCR. There is a very clear form you fill out. There's a very clear mechanism for that. If your market rate, this also touches on good cause eviction because the new good cause eviction law that was just passed, you may be entitled to a renewal lease anyway. But certainly, this is constituting harassment if it's done with the intent for you to either give up your rights. If the question asked about scree, if the landlord is saying you have to, I don't want to take your scree, that would be giving up a right you would have in your housing. If your landlord is saying, you're going to have to leave because I'm not going to deal with a scree tenant, that certainly I think would be enough to show that there is intent. So it depends, but yeah, that would be again go through if it satisfies all the elements of harassment. That's what the tenant would have to show.
Someone asks if they had an HPD inspection or no one showed up, what can I do? And I believe Patrick said tell the court attorney.
That's very frustrating and is something that unfortunately we see quite a bit. You call 311, HPD schedules an inspection, the inspector never shows up. As strange as this might seem, call for a reinspection first and foremost. So call 311 again, make another request, let them know the inspector never came out the first time. Sometimes you get a bad agent on the phone, but you have to calling for reinspection is going to be the best way forward here. Hopefully, I think the new incoming mayor is looking to reform 311 specifically, the process of making complaints. So that may be something to keep an eye out for, but calling 311 again to make another inspection, as Kafkaesque as that may seem, might just be the way to go.
We don't know what's really happening, but we see that someone's calling in to HPD saying the condition's been corrected. And we've yet to really track that down on how to prove if that's the owner doing this. And it's something that maybe Housing Court Answers and all our allies, we can work together to reach out to the city and say what's going on here. So it's a mystery that we need to solve a little bit.
And so just to follow up a question that was answered, certain conditions don't occur when the HPD inspector randomly drops by. So the answer was to get a reinspection. And it is a challenging scenario, and we need to get HPD to understand this reality as well as officials.
Yeah, I can also just to that because that is an important question. And I can give an example from my practice, right? I had a client who every time it rained, there would be like sewage backup or drainage in his apartment, but only when it rained. So it would rain, he would call 311, but then the rain would stop and the condition would be gone, and it would be impossible to predict when there would be rain. He ended up taking videos when it rained, taking pictures, documenting everything, and we were able to use that to negotiate an abatement. There were no violations placed because 311 came and the condition was never there when the inspector came. So there were all of these complaint made, no violation, complaint, no violation, but he had the evidence himself. So that's why it's important to document everything.
Okay.
Michael, what about the Barry's question at the very end? Very, very similar to what you just answered, Nipa.
What's the question?
The tenant did counter the allegation. The landlord requested more access date, but never showed up for the inspection, repair, and any. Oh, okay. This is more about an inspection. I'm sorry. Yeah.
Oh, yeah. So that was the next question. And the landlord requested more access date. So, if you agreed on access inspection date and the landlord never actually shows up, what should the tenant do?
First thing to do is to document it. So if you're there, take a picture at the time of access to show that the landlord isn't there, that the workers aren't there. Reach out to your landlord and say in writing, either email or a text message, and say something like, it is December 12th at 3:41 p.m. and there's nobody here in my apartment. And you can send every hour, because usually access is from 9 to 5 and workers have to arrive by noon. You can just send another every hour. Just document, 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 document. That's going to just be the best thing you can do. Because then when you go back to court, you're going to have to prove that the repairs were never made and that access was never attempted. So that's just why I would suggest document everything.
Um, Sometimes tenants come to HCA's table in court hoping to sue a landlord who refuses to do paperwork that the tenant needs, like a NYCHA rent adjustment or subsidy recertification. Could these failures to act be a basis for a harassment case?
I would I would say so. I think again it's dependent, again going back to the statute. Um, sometimes landlords are not acting with malicious intent. They just don't know what they're supposed to do. But um, you know, even if you can show that I mean, if you don't fill out the proper paperwork and if your landlord doesn't fill out the proper paperwork, usually for NYCHA or for other agencies, they have their own internal mechanisms for making complaints. So that would be the first place if it's, NYCHA or Section 8 or DHCR with rent stabilization. Before you do harassment, you can go and make the official complaint and lodge it with the agency or with the housing provider. Um, if let's say you're going to HRA for a one-shot deal, or this was also an issue with ERAP during COVID, if HRA needs the landlord's information to process a one-shot deal check or to process, whatever benefits, and they're not filling it out, that I would argue could constitute harassment if it is causing you to waive a right, if you're entitled to rental assistance, or if you're not going to be able to keep living in the apartment without this paperwork being completed. I think that satisfies the statute. I think it's certainly worth arguing, but it's worth looking to see if if the specific housing provider itself has its own internal mechanisms.
Okay. I was just wondering, there's two questions. Because especially in Queens, if we can talk about harassment slash, well, harassment, but in basement apartments that are not legal. If you can file one,
Yes.
is it a risk?
Thank you that is a very important point and something that we see in Queens. For illegal basement apartments, it is a little bit risky because yes, a tenant should not be living in conditions. However, there is a risk, and it does happen. HPD comes out and inspects the apartment, um, that they will impose a violation, but the violation will be an illegal basement dwelling, and there will be a vacate order placed on the premises, which effectively means that the tenant cannot continue living there because the vacate order will lock the door, and that's that. So that is something we see, and that is unfortunately a really difficult tightrope walk to navigate. And for tenants in basement apartments, I would suggest certainly reaching out either Housing Court Answers or a legal service provider to talk about different options, because there are still ways and the warranty of habitability still applies, and a tenant should not be forced to live in conditions because the apartment is illegal. But we might need to be a little more creative in how you advocate and get those repairs made.
And then just the environment right now, we have seen where people have been threatened with ICE being called for undocumented persons. Um, yes, we know that's illegal, but what are the risks? I mean,
Yep.
I think we know the risks.
Yep. It's one thing to say something is illegal. It's another thing to say it doesn't happen. And unfortunately, this is happening, and it's happening not just in Queens, across the city and the country, as we know. Um, there are best practices for what I would suggest, and this is in my individual capacity, not necessarily representing legal aid. I think, you know, community safety is really important, and there are a bunch of community organizations that exist to support people, and also can help make the calls and help be there to provide access. So just because you make the call to 311 or HPD doesn't mean you have to be the one there to provide access. There can be a friend, a family member, someone who you trust, who has the key, to let the inspector in. And so, um, if and there are a bunch of overlaying issues here, but you can call 311. And if you have a friend who maybe is a citizen or who feels comfortable letting the inspector in and walking them through, that can be a helpful way to reduce your own exposure for immigration issues or worried about ICE. And I know there are community organizations that will help coordinate that and set that up. I'll also just say that's also why it's important, to talk with your neighbors, and if you have trusted neighbors and friends, that the tenant association isn't just helpful for repairs in your building. It can also be helpful to say, hey, I've got an inspector coming. Would someone mind, hear all the issues? Would you mind just walking them through and showing them all this stuff? Because that can be really helpful. And HPD isn't gonna, they're not gonna care. They see someone with the keys can let them in and put the violations and leave. That's what they're there for. But
I mean, I know.
sorry, I would also just encourage, if people want to have more specific conversations about this, happy to answer emails and talks, off live stream and separately about this stuff too.
Um, when does it make sense to include specific landlord employees as respondents in addition to the actual landlord in a harassment case?
It's a great question. I if you know their names and their addresses, I would say go for it. I think if serving on just a big corporate landlord can be a little bit tricky because you have to find their business address and their mailing address, and you don't know who you're dealing with. If there's a person who's harassing you, who you do know, you can name them personally, make them come to court, and you know, if they're an agent of the landlord and they don't know what's going on, then that might be helpful for the judge to basically yell at them and say, you got to figure this out. And, I would say if just be wary, you have to serve everybody. So if you know their name and address, you have to serve everyone who you named in the same way by certified mail. But if you don't serve, let's say you name 3 people, you don't serve one of them, that one person can be,
I will say the housing maintenance code is pretty liberal about what's considered a landlord in these cases.
yes,
So that's good news.
absolutely.
This PowerPoint was created by, good colleagues of ours, and Michael went over it well. The notice of claim came up. I needed to double check because I used to sue NYCHA. We're not allowed to anymore in our unit. You do not need it for an HP. I just confirmed. I was a little worried that we talked about. That's really wonky. Mike and I try to stay against wonky. That's really what you need when you can sue the city. You basically ask permission to sue the city. It's a really weird thing. So don't stress that. And one thing that Michael pointed out to me too is like the HPs really they're meant to be simple. The reason the courts have a hard time with harassment, they're skeptical without sufficient facts and specificity. I mean, Michael made this real clear to me that he thinks that is the main issue. And so don't get overstressed. Don't think you're going to win the world. Just know that if you're specific and good details, the court will quiz the landlord. And the landlord's going to bark back and say, you're mean, or she's trying to harass me, or she never pays rent. Remember, if it doesn't rebut the allegation, then it's really not relevant. Like, you didn't pay the rent. That's not why we're here, Judge. We're here because of the condition.
Yep, that's a great point. Not paying rent or withholding rent it's not a defense to harassment. That doesn't justify the conduct. Plain and simple.
Can you file a group harassment?
Absolutely. I am so glad you asked that. Yes, absolutely. Groups of tenants can come together and file harassment cases individually and also collectively building wide. And we do this in our practice in Queens and across the other boroughs. Um, Tenants can join together and we will file a very long petition with a million different violations and harassments and put landlords on notice that they're about to be in for a world of pain. But yes, and it can be, for the reasons I mentioned, it can be a lot less scary to do this with your friends and neighbors than it is to go at it on your own. And it can also be for certain tenants, for good reasons, who don't really want to go into court. Seeing your neighbors do it and win can be a really helpful motivating factor to get your own conditions repaired. So yes, encourage it actually.
And then the one last clarification, we also get calls where it's still say um it's not the landlord doing the harassment, it might be a neighbor and the landlord is refusing to intervene. What are the options in that case?
I mentioned this briefly about when the harassment or the behavior is coming from another tenant, and the harassment statute really focuses on the actions of the landlord or the agent of the landlord. So if it is a tenant who has nothing to do with the landlord, but you let the landlord know and the landlord isn't doing anything, and this wades into, our office doesn't, litigate cases against tenants. We don't, prosecute tenants for nuisance or things like that. But you look at the actions of the landlord, and if you think that your landlord is acting in a way, either by ignoring, remember, it can be conduct or a lack of doing something. If you think your landlord is not doing anything because they are trying to get you to move, that would be harassment. So you have to think about it in that context. Why is the landlord not doing anything? Are they just lazy and don't know what they're doing because they have no idea what's going on because they live out on Long Island, have never actually visited our building? Or are they doing it because they think, oh, wait a minute, if this tenant keeps annoying this other tenant, then they'll leave. That would be harassment. So you think about it in the context of the statute.
Yeah, and I think what people really struggle with is like proving it, because while we can definitely connect the dots, proving it is always going to be the hard part.
Yeah, and
I
again,
do.
you don't you rare unless you live in a one or two family unit, you do not have to prove intent. You don't have to prove intent. You just have to prove that the condition is there, which is why it helps to be specific because the burden is on the landlord to show that the intent is not there. So the tenant doesn't have to worry about the intent. It's assumed that the intent is there. The landlord then has to show why it's not. So if you can show, that's why if you have, as specifically as possible, if you say, my landlord's coming over at 3 a.m. every morning and banging on my door for a minute, you don't have to, it's assumed that that's to harass you and get you to leave. And the landlord then has to come up with a reason why actually that's not harassment. So, unless you live in a smaller building, you do not have to prove intent. That's up to the landlord to disprove.
And I think somebody mentioned like we really can't get into personal cases, so that person might want to just call our hotline. Um, but they mentioned like there's a camera that the landlord had placed, and they can ask the courts for or that access to the camera or the recordings. And I'm like, I think here maybe like the subpoena power or subpoena request might be a powerful tool.
Yeah, individual cases, the hotline would be helpful for that because there are all sorts of, you'd have to look at your lease and you'd have to think about where the camera is, where it's located, where it's pointed. But that's a perfect thought about um, ways to provide, proof and evidence. That's exactly the right way to be thinking about how can I get as much proof as possible to show. And there are discovery motions. There are ways you can try and get access to certain records, but that would be a question for an attorney or a little more specific.
Definitely. Okay, so I don't think we have any more questions, but this was such a great training. So thank you to everyone. I do want to point out if you have tenants, we actually have a training for tenants geared specifically for tenants on our website, and I'm going to share the link. So it's actually next week, and we have these trainings every month. So we have trainings for like holdover non-payment cases, and HP action for repairs too. So a follow-up training, how to sort of represent yourself. This is more geared towards like organizers, but again, like everyone, you guys can feel free to attend that training. You can send your attendance. Just a more basic version of this training, obviously not as well as this one. But again, thank you so much for this training. We really appreciate it. Definitely got a lot of information. And remember, this training will be on our website along with the presentation. And to everyone, happy. Our next organizer training is not until the new year. So in the meantime, everyone, happy holidays and happy new year.
Thanks, Nipa.
Of course.
Thanks,
Thank you
everyone.
guys again.
Thanks, Michael.
Thank you.